Moreover, there's a further asymmetry in some of the underlying fundamental rights. While it's all true that the same principles are expressed in both Europe and the US, there's a fundamental difference in the enforceability of those principles. The overarching treaty basis that incorporates those principles as they relate to many of the things for which this data is used for is the International Covenant on Civil and Political Rights, which the U.S. ratified with the reservation that it was not self-effectuating and has never enacted any explicit effectuating legislation for. So the ICCPR is largely moot in the U.S. and unenforceable. So we have that asymmetry where we have a proposed agreement that would be enforceable in the EU and potentially could implicate rights that are enforceable now as treaty rights, whereas the treaty rights aren't enforceable now in the US, the agreement wouldn't. Where does that leave us? Why do we have this proposal then, if that's what's going on? Obviously, neither DHS nor other US agencies need this agreement for two reasons. First, because they don't need to override the non-existent US data protection law with respect to access to commercial data. There is none, so they don't need any change. And they don't need to override the International Covenant on Civil and Political Rights because it's already non-self-effectuating and unenforceable here. The second reason the US government doesn't need this agreement is because they're already getting much of this data already or have other ways that they could get it. PNR data, European airlines already outsource, and US airlines that operate in Europe already outsource their data hosting to computerized reservation systems based in the US. SWIFT had, until recently, mirror servers in the US with all their financial data. Large amounts of internet, e-commerce data, communications data, it's all moving through servers and hosts in the US even when it's going between other continents. US government can already get that data without having to go to a European government to get it because the data actually resides or is passing through the US and the US can get it under the Patriot Act from computerized reservation services, banks, telecommunications companies, under those provisions or under FISA provisions already without the need of this agreement. To what degree they are, we don't know because of the secrecy of many of those mechanisms. But DHS is already getting this. So why... And besides which, well, so why, DHS doesn't need this. Privacy advocates have nothing to gain from this because the US has already said they're not going to change US law to grant us any more legal rights with respect to privacy or other fundamental rights. And in Europe, nothing is being proposed that would increase protections under European privacy law. Privacy advocates have nothing possibly to gain from any form that this agreement in its present form might take. So who needs it? Who wants it? The agreement potentially could benefit two groups of people. One, businesses that are already transferring data in the commercial sphere from Europe to the US or outsourcing data processing to the US or transferring data directly to the US government, although that's probably the least common of these mechanisms, in violation of existing EU law, who know that while EU enforcement authorities have done nothing about this to date, they're at least at risk of liability under EU law. It would relieve that cloud. It would function then as an immunity law to grant them protection against the possibility of enforcement action for the things they're doing now that clearly violate EU data protection law. Secondly, this law would let European data protection authorities who are reluctant or unwilling to enforce their existing laws off the hook for their failure to do their job of policing the existing illegal transfers of data in the commercial sphere, particularly, but then to the US by companies that do business in Europe. And although there is a distinction, I think it's a false distinction between commercial transfers and transfers directly to the US government. Given the Patriot Act provisions and existing mechanisms of US law for government access to commercial data once it is in the US, commercial transfers of data to the US are tantamount to placing the data within the grasp by secret mechanisms without judicial accountability of the US government and need to be treated as such. So I think what we need to think about this proposed agreement as being fundamentally is a law to remove the possibility of liability for businesses that are breaking EU privacy law in their dealings with the US, and to remove even the possibility that EU data protection authorities might take up their existing mandate to impose sanctions against them. And fundamentally, unless the US government is willing to make this a treaty, which was part of the the European Parliament resolution on PNR, part of their terms of reference was that it needed to be a treaty that respected the ICCPR. Unless the US is willing to make this a treaty that's binding, and to make changes in the US law to comply with it, if the US is unwilling to do anything, the only thing that is being negotiated now is exactly how much of the current protections of European privacy and fundamental rights law will be signed away by the European Union. That no more and no less. So what's needed? The US is not negotiating in good faith. They have no motivation to. This isn't going to be binding on them, and they've already said they're not going to change their laws. What would be needed to actually bring the US to a real negotiating table of bargaining? The US is going to need to negotiate if and only if they really fear that US companies are going to feel some pain from enforcement of existing EU law. The pathway to bringing them to the negotiating table is for European data protection authorities and the European Commission itself, which has enforcement responsibility under, for example, the EU Code of Conduct for CRSs, begin to actually impose sanctions costly enough to affect the annual reports and the bottom line of those companies. Then when they feel that pain, the US will feel the necessity to actually start negotiating in good faith. And everybody knows that if airlines flying from Europe don't provide advance access to their passenger manifests, the US won't let their planes land. There is complete confidence on the US side that nobody in Europe is willing to take comparable enforcement action and refuse to let planes land or let airlines operate there if they're not willing to comply with existing EU data protection law. That has to change. And the initiative, I don't think, unfortunately, is going to come from the Commission or from Parliament. That is going to come, if at all, only through grassroots action by European citizens making complaints to their data protection authorities and demanding that they actually enforce those stronger European privacy laws that sound so good to us Americans in theory, but actually have proved hollow, as we've seen, for example, in the complete and total failure of the safe harbor scheme.
2 minutes.
Okay. A couple of things that, if it were a treaty, and if it were based on removal of the US reservations on the ICCPR, something that was raised not just by me, but by European NGO witnesses at the hearings on the PNR agreement that Jan Philip chaired last year in Brussels. Beyond that, what would be needed would be to recognize a principle that mere effectiveness in policing is not a sufficient argument to satisfy standards of proportionality or, as the ICCPR phrases it, necessity. You know, if you break into everybody's house, have house-to-house searches, you will find crime in most people's houses. The fact that you would find that does not mean that house-to-house searches of people who are not now suspects are justified. And one of the characteristic things about most of the data collection and transfer that would be encompassed by this agreement is that it is not case by case. It is not based on suspicion, because there are existing legal mechanisms for acquiring all of this data under existing law enforcement cooperation agreement if there is suspicion, if it is part of a specific investigation. The only reason for new and broadened agreements is to gain access to dragnet surveillance data of non-suspects. It also is intended to require that this surveillance capability in many cases be embedded in commercial infrastructure. And I will not attempt to repeat here, but on this point I would strongly refer all of you to Susan Landau. I don't know if she's here, but her new book describing and detailing the threat to security posed by embedding surveillance capabilities in information technology infrastructure. So I hope that there will emerge the kind of grassroots privacy movement in Europe that I think we have to a slightly greater degree here. But without that, I think we need to recognize that while some may see this as an attempt to place under regulation existing unregulated transfers, no good can come of this in its present form, and it needs to be fundamentally reformed in its legal basis to have even the possibility of serving to protect our rights. Thank you.
So, we now have.
What we're going to do now is give each of the panelists who've spoken this morning, and Frank Schmiedel, the European Union delegation here in Washington, the opportunity to offer any follow-up comments based on what they've already heard. And we'll ask you just to speak for about 2 minutes, if you could, please. And why don't we just basically go in the same order, except we can start with Frank, if it's all right with you, in place of Vice President Reddick. We may never hear from her.
No, of course I cannot replace her, but I'd have a...
I'm going to tell her that you said you were going to replace her.
I'm leaving here, so... I think maybe a few comments to what Edward Hasbrook has just said. We have also read with interest the letter that a number of US NGOs have sent to President Obama and to the Congress, expressing the worry of the European Union signing away European privacy rights in these negotiations with the US government, and by implication also lowering the standard of privacy in the US. I think I'm not quite as cynical as Edward has been. We are very happy about the vigorous debate currently developing in the United States on the importance of privacy and data protection, and I think we have the chance to reach a higher level of privacy and data protection on both sides of the Atlantic. If we do it right, if we do some creative thinking now, as Cameron Carey has said, I think now is the moment, perhaps not only on the side of commercial privacy, but also on the side of law enforcement privacy, to engage in some creative thinking across the Atlantic, how we can improve protection for our citizens and overcome our differences. Let me point out that in the EU there is still a widespread perception that data exchanges have been largely a one-way street over the last years, with huge amounts of personal data of Europeans being gathered by the US authorities. I keep joking, the US authorities know our citizens better than our own authorities, which is probably true to some extent. So I think we are right to insist on more transparency. I think the US government has already made important efforts in that direction, and we appreciate that. More protection of our rights, of the rights of Americans and Europeans alike, irrespective of nationality or residence. And also more reciprocity. In our understanding, that would mean more sharing of the derived intelligence from these data to prevent security threats and counter security threats. And we are building our own similar systems now, so sooner or later we might actually come to your door and ask for your data, and then we would expect reciprocal treatment, of course, as well. So I think if we engage in this creative thinking and find solutions that can satisfy our respective legal orders and political constraints, I think we can make these data exchanges that are taking place, and I'm afraid won't go away, can make these exchanges both legally and politically sustainable for the future, and perhaps also increase them in duly justified circumstances. So from the European perspective, I would say, if you allow me to paraphrase President Kennedy, don't always ask when it comes to data protection and data what Europe can do for you. Also ask yourselves what you can do for Europe to assuage our concerns. Thank you.
as they relate to many of the things for which this data is used for, is the International Covenant on Civil and Political Rights, which the U.S. ratified with the reservation that it was not self-effectuating and has never enacted any explicit effectuating legislation for. So the ICCPR is largely moot in the U.S. and unenforceable. So we have that asymmetry where we have an proposed agreement that would be enforceable in the EU and potentially could implicate rights that are enforceable now as treaty rights, whereas the treaty rights aren't enforceable now in the US, the agreement wouldn't. Where does that leave us? Why do we have this proposal then, if that's what's going on? Obviously, neither DHS nor other US agencies need this agreement for two reasons. Already or have other ways that they could get it. PNR data, European airlines already outsource, and U.S. airlines that operate in Europe already outsource their data hosting to computerized reservation systems based in the U.S. SWIFT had, until recently, mirror servers in the U.S. with all their financial data. Large amounts of internet, e-commerce data, communications data, it's all moving through servers and hosts in the U.S. even when it's going between. Moreover, there's a further asymmetry in some of the underlying fundamental rights. While it's all true that the same principles are expressed in both Europe and the US, there's a fundamental difference in the enforceability of those principles. The overarching treaty basis that incorporates those principles first, because they don't need to override the non-existent U.S. data protection law with respect to access to commercial data. There is none, so they don't need any change. And they don't need to override the International Covenant on Civil and Political Rights because it's already non-self-effectuating and unenforceable here. The second reason the U.S. government doesn't need this agreement is because they're already getting much of this data